afternoon, distinguished guests, ladies and gentlemen. Welcome to the National Security Legal Forum 2026, organized by the Department of Justice. I'm your host, Esther Chen. On the 10th of February this year, the State Council Information Office published the white paper titled Hong Kong, Safeguarding China's National Security Under the Framework of One Country, Two Systems. The white paper provides for a comprehensive summary and a systematic review of Hong Kong's endeavors in safeguarding national security in Hong Kong. To kick off today's forum, we are honored to invite the Honorable Paul Lam Ting Kwok, GBS-SC JP, Secretary for Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, to deliver the opening remarks for us. SJ, please.
Professor Wang, distinguished guests, ladies and gentlemen, a very good afternoon. Welcome to the National Security Legal Forum, organized by the Department of Justice. The theme of this year is the white paper published on the 10th of February titled Hong Kong, Safeguarding China's National Security Under the Framework of One Country, Two Systems. This is an extremely important document, being the third white paper issued by the Central People's Government on Hong Kong after the practice of the One Country, Two Systems policy in the Hong Kong Special Administrative Region in June 2014 and Hong Kong democratic progress under the framework of One Country, Two Systems in December 2021. One must know the past to understand the present. The white paper clears up confusion and misunderstandings by reviewing comprehensively Hong Kong's endeavors in safeguarding national security and the experience and insights gained in the process. In addition, to build high-standard security in order to support high-quality development of Hong Kong, the white paper set out 6 fundamental principles. They are upholding the unity of the central government's fundamental responsibility and Hong Kong SAR's constitutional responsibility, keeping the power of governing the Hong Kong SAR firmly in the hands of patriots, respecting and ensuring human rights, safeguarding security under the rule of law, following a holistic approach to development and security, and safeguarding security with greater openness. I would like to share my views on some of the most salient features among these principles. First and foremost, it's made crystal clear that Hong Kong does not pursue absolute or generalized security. This is indeed and has always been the crux of our country's approach to national security. To begin with, as stated in the outline for the study of a holistic approach to national security, published 4 years ago on the 15th of April 2022, it is necessary to respect and safeguard the security of each and every country. Hence, it should not be the case that one country is safe whereas other countries are unsafe, or that some countries are safe whereas others are unsafe. It's also wrong to pursue one country's so-called absolute security by sacrificing other countries' security. Second, in the Global Security Initiative, the GSI, concept paper published by the Ministry of Foreign Affairs on the 21st of February 2023, it reaffirms that China stays committed to taking the legitimate security concerns of all countries seriously. Security of one country should not come at the expense of that of others. All countries are equal in terms of security interests. The legitimate and reasonable security concerns of all countries should be taken seriously and addressed properly. Any country, while pursuing its own security, should take into account the reasonable security concerns of others. Lastly, in the white paper published by the State Council on the 12th of May 2025, titled China's National Security in the New Era, apart from referring to the content of the GSI, it pointed out that pursuing power supremacy and absolute security will only result in a security dilemma. Therefore, instead of absolute security, China pursues relative security. This fundamental approach is given the force of law. Article 2 of the National Security Law of the People's Republic of China, which is reproduced in Section 4 of Hong Kong Safeguarding National Security Ordinance, defines national security as a reference to the status in which the state's political regime, sovereignty, unity and territorial integrity, the welfare of the people, sustainable economic and social development, and other major interests of the state are relatively free from danger and internal or external threats, and the capability to maintain a sustained status of security. It's vital to note that it says relatively free from danger and internal or external threats, but not absolutely free from danger and such threats. To pursue absolute security is not only contrary to the fundamental principle of peaceful coexistence under international law and international relations, it's also unsustainable in practice and will stifle development which is against the interests of a country's own people. Hence, another important principle set out in the white paper is to follow a holistic approach to development and security. It highlights the causal link between security and development. Security is a prerequisite for development, whereas development provides a guarantee for security. We strive to strike a dynamic balance between development and security so that the two reinforce each other. Such a holistic approach is based on common sense and simple logic, and is also proved by empirical evidence of events taking place in other parts of the world at this very moment. This fundamental approach is of particular importance to Hong Kong. Under the principle of one country, two systems, Hong Kong enjoys various unique strengths, all of which aim at enabling Hong Kong to serve as an international center in different areas, such as finance, trade, shipping, as well as legal and dispute resolution services. The key word to Hong Kong's success is international. To serve as a general international city, it's essential to gain and maintain people's trust and confidence that Hong Kong is an open, inclusive, and diversified society. This is why another principle laid down by the white paper is that Hong Kong aims at developing open security, which emphasizes safeguarding national security in an open environment. Examples given include that Hong Kong will continue to employ judges and other judicial professionals from other common law areas, and its Court of Final Appeal will continue to invite such judges to participate in trials as needed. Lawyers from other areas will continue to work and practice law in Hong Kong in accordance with the law, and the lawful rights and interests of investors from all countries and regions will continue to receive equal protection. To achieve relative security and open security in Hong Kong, the white paper laid down two further important principles, namely, first, respecting and ensuring human rights, and second, safeguarding security under the rule of law. These two principles also enjoy the force of law. Article 4 of the Law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region, the NSL, provides that human rights shall be respected and protected in safeguarding national security in Hong Kong, the rights and freedoms which residents of Hong Kong enjoy under the Basic Law and the provisions in the International Covenant on Civil and Political Rights as applied to Hong Kong shall be protected in accordance with the law. Article 5 provides that the principle of the rule of law shall be adhered to in preventing, suppressing, and imposing punishment for offences endangering national security. Hence, a person is presumed innocent until convicted by a judicial body. The right to defend himself or herself and other rights in judicial proceedings that a criminal suspect, defendant, and other parties in judicial proceedings are entitled to under the law shall be protected. Article 4 and 5 of the NSL have been reproduced virtually in verbatim in Section 2 of the Safeguarding National Security Ordinance as the principles on which the ordinance is based. One may ask, how can one be reassured that these legal requirements will be faithfully followed in the enactment and implementation of the national security laws? Again, the white paper provides the answer. It specifically states that the judicial authorities of Hong Kong SAR exercise adjudicative power independently and in trying cases pertaining to national security in accordance with the law are free from any interference. The important role played by Hong Kong court in this respect was explained by the Court of Appeal in the case Secretary for Justice and persons conducting themselves in any of the acts prohibited under paragraph 1A, B, C, and D of the endorsement of claim, 2024 HKCA 442, also reported in 2024 Volume 3 of the Hong Kong Law Report and Digest, page 32. The Chief Judge of the High Court, giving the judgment, held that in discharging its judicial function in cases involving national security, the Court will give appropriate deference to the executive, but will make its own judgment on the issue as required. And there are at least 3 areas where the Court has been held to be qualified to make its own judgment while giving the executive deference, and they involve issues of constitutional or legal nature or content. First, where a fundamental right of the person affected by the measure is engaged. Second, where the requirement of fair trial is an issue. And third, where the question of open justice is raised. In another case, Hong Kong SAR and Tang Ok Kwan, 2025 HKCFA 3, reported in 2025, Volume 28 of Hong Kong Court of Final Appeal Report, page 29, the Court of Final Appeal held that our courts have frequently acknowledged their duty under Article 3 of the NSL to effectively prevent, suppress, and impose punishment for any act or activity endangering national security, and the importance of that duty. However, it bears emphasizing that carrying out that duty requires the court faithfully to give effect to the provisions of the NSL and other applicable laws, including the safeguards provide for fair trial. As the white paper aptly observed, national security, like air and sunshine, is something without which we cannot survive, but too often mistakenly taken for granted. We must therefore arouse the awareness and vigilance of people in this respect. We must also provide people with a proper and sufficient understanding of the fundamental principles that Hong Kong follows in safeguarding national security. This is to ensure that the national security laws of Hong Kong will be assessed objectively and rationally, and that they will be accepted and followed voluntarily and willingly out of a genuine belief and conviction that they are essential and beneficial to our well-being, but not something that one may feel apprehensive about. To achieve this objective, I would urge you all and whoever is genuinely concerned about Hong Kong to study the white paper carefully. And before I conclude, I would like to thank Professor Wang and all the guest speakers for agreeing to share their insights with us this afternoon. I wish you a very constructive and productive forum. Thank you very much.
Thank you. Thank you very much, Ms. Jade. And please have a seat. Today, it is our great honor to invite Professor Wang Zhenmin to deliver the keynote speech. Professor Wang is the Vice President of the Chinese Association of Hong Kong and Macau Studies, Dean of the Institute for Governance Studies, IGS, Tsinghua University, and Professor, School of Law, Tsinghua University. 今天我们是非常的荣幸可以邀请到王正明教授为我们做主题演讲。王教授是全国港澳研究会副会长，清华大学国家治理研究院院长，清华大学法学院教授。有请。
Honorable Mr. Paul Lam, friends, colleagues, ladies and gentlemen, good afternoon. Great to see you all. It's really a privilege and honor to be invited to speak on this prestigious legal forum. The topic today is about the white paper on China's national security in Hong Kong. I wrote academic papers every year, but this paper is very different. It's governmental official paper expressing the government policy towards some very important issue. To better understand and practice law, you need to understand the policy. So that's why the white paper is so important. I have 30 minutes. I will share you my initial observations and ideas about the white paper in 3 aspects. Now I will change to speak in Mandarin Chinese. 第一个问题就是为什么发表这个白皮书？白皮书是中国政府就国际国内关注的重大问题发表的彰显事实真相、表明原则立场、宣示政策导向的官方权威文件，代表国家意志，发挥一锤定音的作用。刚才林司长已经讲了，关于香港问题，中国政府发表过3个白皮书，从2020年以来，这是第2份白皮书。2021年12月20号发表的《一国两制下香港民主发展的白皮书》，讲的是中国政府和中国共产党创造香港民主的这个基本事实，宣示了中国政府对香港民主发展的原则立场。2020年6月30号，香港国安法实施以来，香港维护国家安全取得的成效、成就有目共睹，波澜壮阔的历史清晰可见。但是，个别西方政客、媒体一直大搞双标，故意颠倒黑白、造谣抹黑，对中央和特区维护国家安全的各种攻击从未停止。这些攻击包括说香港国安法违反一国两制，破坏香港法治，破坏香港的营商环境，甚至有某一个国家的总统讲香港现在已经是一国一制，香港内地化，攻击维护国家安全、侵犯人权自由等等等等。个别大国甚至以谎言为基础，对有关人士实施制裁。这英文呢有一句话，这 "Seeing is believing"。我们各位身处香港，每一天都在见证一国两制在香港的勃勃生机和无限的活力。事实胜于雄辩。中央政府和特区政府、社会各界对这些攻击抹黑都进行了及时的反驳、反制，但是仍然需要 系统完整的把中国政府出台实施香港国安法，中央和特区在香港维护国家安全背后的考虑，中央政府的原则立场、实践要求等等，以官方白皮书的形式，一次性向世人讲清楚。这个白皮书呢，就是中国关于香港维护国家安全历史的全面总结和系统梳理，重点是2020年以来在特区维护国家安全的重大事件、重大行动和重要成果。去年以来，特区法院就有关的重要的国安案件作出了判决，维护国家安全取得了重要的阶段性成果。在这个时间节点发表一份这样的白皮书啊，是十分适宜的。顺便也做一个比较，明年是香港回归祖国30周年，这30年，中国政府就香港问题只发表了3份白皮书，也就是说每10年1份白皮书。相比之下，英国每半年发表1份关于香港问题的 paper report， 到现在为止已经发表了58份之多。我们10年发表1份，他们是每半年发表1份。美国政府每1年发表1份，到现在发表了26份。美国国会每半年发表1份，到现在也发表了26份。美国加起来一共是发表了52份之多。也就是说，在国际场合关于香港的话，都让他们讲了。我们10年综合性的讲1次，算多吗？第二个问题就是白皮书的主要的内容和原则精神。白皮书前言重点讲了发表白皮书的目的，正本清源，凝聚共识。香港维护国家安全的目的非常的清晰明确，那就是为了捍卫一国两制，维护国家主权安全发展利益，保持香港长期繁荣稳定，是为了国家好，为了香港好，为了我们每一位香港居民好。安全不是紧箍咒，而是护身符、助推器。白皮书的第一部分，维护国家安全的斗争从未停止，回顾了2020年以前围绕维护国家安全斗争的历史，讲清楚了一件事情，就是维护国家安全呢，从来是一国两制的应有之义，不是2020年才提出来的，是一国两制提出之初，维护国家安全就是它的必然的要求。回归后，香港基本法23条立法成为维护国家安全斗争的焦点。由于种种因素，特区长期未能完成23条立法，导致特区维护国家安全存在严重的漏洞，给反中乱港势力和外部敌对势力以可乘之机。2019年修例风波对国家安全造成了最严峻的挑战，国家安全面临着重大而现实的威胁。这是第一部分。第二部分呢，讲的是2020年以来，中央政府如何履行自己对维护国家安全的根本责任。在特区自身无法有效地维护国家安全的情况下，从中央层面行使限制权力，立法维护国家安全，势在必行。2020年以来，中央采取的主要的措施，包括制定实施香港国安法，依法安香港。白皮书批驳了对香港国安法的各种攻击，特别是鼓吹香港国安法改变了一国两制，完全违背事实真相。香港国安法是对基本法维护国家安全内容的补充 发展完善。香港基本法和香港国安法共同构成了香港维护国家安全的重要的基础。这是白皮书一个非常重要的表述，讲清楚了香港基本法和香港国安法在维护国家安全方面的关系。国安法没有修改，更没有取代基本法，而是对基本法的补充完善。第二，当然就是完善选举制度，守牢特别行政区的管制权。中央采取这些措施，对香港实现由乱到治的历史性转折发挥了决定性的作用，具有重要的里程碑意义。这是第二部分。第三部分呢，讲述了2020年以来香港特别行政区如何履行维护国家安全的宪制责任。一是我们大家都见证了历史性的完成了基本法23条的立法；二是持续的完善香港特区维护国家安全的这有关的法律制度，构建了这个完整的维护国家安全的法律体系；三是有力地开展了维护国家安全的执法和司法。这今天上午的会上，这邓炳强局长也举了这个例子白皮书呢也这个用了这个数字就是2020年以来到今年1月依据香港国安法，共有98人被检控，78人被定罪，最高判刑20年。在这里我也想做一个比较英国2011年伦敦暴乱持续5天，死亡5人，近4000人被逮捕，3103人被起诉，2138人被定罪重判，最高刑期长达30年。2021年持续1天的美国国会山暴乱更是动用了军队，死亡5人，1575人被检控，1126人被定罪，最长刑期22年。所以我们看到一些国际上的攻击说香港这个维护国家安全这个不讲人权好像是这个侵犯了这个一些人的权利我觉得这些数字很生动地说明了香港维护国家安全是依法精准，靶向治疗，打击的确确实实是极少数，保护的是绝大部分广大市民的安全和福祉。第四部分，香港实现由乱到治，走向有志极兴，讲的是维护国家安全这个成效、成就这个4个方面我在这里就不再一一列举了因为我们大家这个都是感同身受第5部分，以高水平安全护航一国两制事业高质量发展，是对一国两制条件下香港维护国家安全实践规律的概括总结和理论升华，宣示中国政府对过去几年发生的一些重大问题的观点看法和原则立场，是整个白皮书的灵魂，理论性、思想性极强，同时也是对未来特区维护国家安全工作提出的实践要求，具有很强的现实指导意义。白皮书用6个坚持这个对过去这几年维护国家安全做了这个总结概括有很多金句有很多新话。第一呢刚才林司长也讲了就坚持中央和特区两责统一这个白皮书这个明确地讲，一国两制下香港维护国家安全是中央政府和特别行政区的共同责任也都有责任中央主导，特区主责，符合一国两制方针面对复杂多变的形势，必须把维护国家安全贯彻一国两制实践的全过程维护国家安全只有进行时，没有完成时，必须确保香港不能再乱，这是底线，也是我们的生命线。第二点， 坚持把特别行政区管制权牢牢掌握在爱国者手中，把政治安全摆在首位，全面贯彻落实爱国者治港原则，同时必须维护宪法确立的国家根本制度和国家政权的安全，这也是白皮书这个把特区政权安全和国家政权安全的关系，把它这里面的逻辑联系讲清楚了。第三是坚持尊重和保障人权。香港维护国家安全的实践不追求绝对安全或者泛化安全，强调保护居民依法享有的各种权利和自由。香港居民和法人与其他国家地区正常的交流，以及在香港外国人的各项权利依法受到充分的保障。第四，坚持在法治的轨道上维护安全。特别行政区维护国家安全，严格依照宪法、基本法、香港国安法以及本地法律开展工作，有法必依，违法必究。我们从这些案件法院审理的这些案件可以看到，这没有冤枉任何一个人，凡是被起诉、被定罪的，那都是这个证据确凿，这个法律清楚。特区司法机构独立行使审判权，依法审理涉及国家安全的案件，不受任何干涉。中央驻港国安公署严格依法履行职责，依法接受监督。第五，坚持统筹发展和安全。过去呢，在这个问题上是有一些糊涂的认识，那么白皮书呢明确地指出，推动发展绝对不能忽视安全，维护国家安全是为了让香港更好的发展，让香港居民过上更好的日子。发展是硬道理，安全也是硬道理。要把香港的繁荣发展建立在确保安全的基础上。第六是坚持在开放中维护安全。一国两制下，香港维护国家安全塑造的是开放型安全，在开放的环境中动态维护国家安全。刚才林司长对这个问题做了非常精辟的阐述。既要坚定不移地维护国家安全，又要坚定不移地保持开放，在开放中保安全，以安全促开放。特别是这个白皮书呢，指出来，在香港维护国家安全呢，不仅仅是保持香港的繁荣稳定，也不仅仅是维护中国的主权安全发展利益，也是要维护全球产业链、供应链、资金链的安全。作为一个国际金融中心呢，在香港维护国家安全，也是维护国际经济金融平台和交易的安全，是维护经济全球化的贸易自由化的国际秩序。坚持在高水平保障下推进高水平开放，确保营商环境更加自由开放。这个白皮书呢，很详细地列举了这个基本法的一些规定，所以这些规定呢，在今天我们再来重温，我觉得具有非常重要的意义。比方说，白皮书呢重申，香港继续从其他普通法适用地区聘用法官和其他司法人员，外国律师继续依法在港工作执业，世界各国各地区投资者的合法权益继续得到平等保护。这是香港非常独特的也就是这个外国居民外国公民，只要是香港永久居民和本国公民在香港享有同等的基本法保护的这些权利这包括选举权被选举权是吧？担任公职的权利这些都没有改这都是基本法明文规定的白皮书重申，无论国际风云如何变幻， 中央政府将一如既往全面准确、坚定不移贯彻“一国两制”、港人治港、高度自治的方针，强调了3个长期不变，保持香港资本主义制度和生活方式长期不变，保持香港国际自由港和单独关税区地位长期不变，保持普通法制度长期不变，3个保持长期不变，切实地保护私有财产、企业所有权、合法继承权以及投资者在香港的安全和合法权益。这白皮书强调呢，香港维护国家安全的实践，不仅夯实了“一国两制”实践的安全根基，而且进一步充实了我们全国国家安全的体系，对在高度国际化、全面开放条件下如何维护国家安全进行了成功探索，也丰富了中国特色国家安全道路的内涵，也为各国各地区维护国家安全做出了新的示范。这是第5部分是白皮书的这个理论性、思想性最强的这部分。结束语呢是一个总结，指出了香港维护国家安全的实践呢，本质上是坚持和发展“一国两制”事业的实践。有了高水平、安全的香港，前景无比光明。那么最后呢，我想讲一讲这个白皮书它所宣示的，也就是在香港维护国家安全它的国际意义也就是我们要共同的守护“一国两制”蕴含的和平、包容、开放、共享的价值理念。白皮书不仅总结过去，而且指明未来，对我们下一步深入贯彻实施香港国安法有非常重要的指导意义。经过学习呢，我相信大家对5年多来香港维护国家安全的实践呢，也有了更多的认识和理解，对香港光明的未来有了更大的信心。因为今天呢有很多这外国朋友我想讲一讲这个香港维护国家安全的实践它的国际意义。大家还记得1984年2月12号，邓小平先生会见了一些研究国际问题的学者那么当时呢，他讲世界上有许多争端，总要找一个解决问题的出路。我多年来一直在想，找个什么办法，不用战争手段，而用和平方式来解决这种问题。这就是我们的一国两制。请你们好好的了解和研究一下我们对台湾、香港问题提出的解决方式，总要从死胡同里找一个出路。1990年2月17号，他在会见香港基本法起草委员会委员成员的时候，讲到基本法具有的2大意义，一个是历史意义，一个是国际意义。他讲呢，基本法具有国际意义，不只对第3世界，而且对全人类都具有长远意义。2年前，2024年12月24日，习近平主席在庆祝澳门回归祖国25周年大会的讲话中指出，一国两制蕴含的和平、包容、开放、共享的价值理念是中国的，也是世界的，值得共同守护。当前100年变局加速演进，世界变乱交织，动荡加剧，地区冲突此起彼伏。中东战火各国皆输，没有人赢，没有人从战争当中得到什么好处。与此形成鲜明对比的是，在风高浪急乃至惊涛骇浪的世界里，中国正在按照自己的议程统筹发展和安全，稳步推进第15个5年规划的落实，续写经济快速发展与社会长期稳定2大奇迹， 为动荡不安的世界提供了难得的稳定性和确定性。曾几何时，大家都记得，香港也曾经是中西方对立冲突、剑拔弩张的前沿阵地。得益于“一国两制”的伟大创举、伟大实践，我们化干戈为玉帛，香港成为中西方合作共赢之地。在今天战火纷飞的世界，“一国两制”下的香港稳如泰山，维护国家安全的红利日益彰显，正在重新成为国际投资的热土，成就梦想的宝地，再次展现了其独特的优势、魅力和价值。这是一个非常鲜明的对比。一个是双赢多赢之地，一个是变成了双输多输之地。这就是“一国两制”的伟大贡献，这就是“一国两制”，这就是我们在香港维护国家安全的国际意义。所以今天我们把习近平主席的话我们重新学习，把邓小平当年讲的话我们重新来学习，我觉得更有现实意义。让我们共同守护“一国两制”蕴含的价值观念，让香港继续成为不同种族、不同民族、不同社会制度和平共处、合作共赢之地，为各国各地区维护国家安全做出我们新的示范，为人类的文明进步、为打造人类命运共同体做出独特的香港贡献。谢谢大家。
非常感谢王教授，谢谢，请就坐。Thank you very much, Professor Wang, for delivering such an inspiring keynote speech. We will now proceed to our first panel discussion, Clearing Up Confusion, the Endeavors of Hong Kong in Safeguarding National Security. The forum's panel session 1 will review Hong Kong SAR's continuous efforts to implement our constitutional duty to safeguard national security by refining our legal regime and enforcement mechanism, and also enforcing the relevant laws, which demonstrate that whether in legislation, law enforcement, or judicial decisions, Hong Kong SAR strictly upholds the rule of law principle and protects human rights. In this session, we are honored to have Mr. Jonathan Zheng, SC, to be our moderator. Please welcome. And may I also invite our panelists, Honorable Carmen Khan, JP. Mr. Anthony Chow. And Professor I. Granville Cross, GBS SC. So, ladies and gentlemen, please join me in welcoming our panelists and also our moderator. Thank you. Thank you very much, and please have a seat. And may I now pass the time to Mr. Zheng, please.
Secretary for Justice, Deputy Secretary for Justice, Professor Wang, distinguished guests, ladies and gentlemen, safeguarding national security is one important facet of maintaining the one country, two systems policy in Hong Kong to uphold national security, national unity, and territorial integrity. Now, we are here to speak about the white paper published by the State Council Information Office on the 10th of February 2026. The white paper comprehensively reviews the long journey of safeguarding national security in Hong Kong and provides solid support and valuable insights for the steadfast and successful implementation of one country, two systems. It covers 5 areas. First, the unrelenting fight to safeguard national security in Hong Kong. Second, the central government's fundamental responsibility for national security matters concerning Hong Kong. Third, the Hong Kong SAR's achievements in fulfilling its constitutional responsibility to safeguard national security. Fourth, Hong Kong's transformation from disorder to stability and prosperity. And finally, establishing high standard security to support high quality development of the one country, two systems policy. Our three speakers will review the development of Hong Kong's laws on safeguarding national security and related judicial cases from three different aspects: legislation, implementation, and comparative analysis. In the process, the panel will delve into a focused discussion on the Hong Kong SAR's achievements in fulfilling its constitutional responsibility for safeguarding national security in the past years, also in compliance with the substantive and practical requirements of the White Paper. Now, may I introduce our first speaker, the Honourable Carmen Can. Ms. Can was qualified as a solicitor in Hong Kong in 1993 and is a member of the current Legislative Council. She chairs the Legislative Council panel on administration of justice and legal services. She was a member of the Bills Committee and Subcommittee vetting the Safeguarding National Security Ordinance and its subsidiary legislation. She also chaired the joint panel meeting on the 2026 implementation rules for amending the implementation rules for Article 43 of the law of the People's Republic of China on safeguarding national security in the Hong Kong SAR. As stated in the White Paper, the fight for safeguarding national security in Hong Kong is unrelenting, and national security risks still exist. In accordance with the Hong Kong National Security Law and the Safeguarding National Security Ordinance, the Hong Kong SAR has enacted, revised, and refined relevant local laws based on actual needs, providing a more concrete and complete institutional guarantee for safeguarding national security. The legislative amendments discussed by Ms. Can will show how the Hong Kong SAR government fulfills its constitutional duty to continue to improve the legal system and enforcement mechanisms for safeguarding national security. Ms. Can.
Thank you, Jonathan. Distinguished guests, ladies and gentlemen, it's a great honor to have been invited by the Department of Justice to speak at National Security Legal Forum on the topic Clearing Up Confusions and Misunderstandings, Hong Kong's Endeavors in Safeguarding National Security. In my speech, I will focus on the role of Hong Kong SAR to continuously refine and improve our legal system and enforcement mechanism for safeguarding national security from a legislative perspective. And I will talk about three legislative exercises in 2025 and this year, which illustrate Hong Kong SAR's efforts in safeguarding national security while adhering to the rule of law and protecting human rights. Now, as I have put up the slides, allow me to use some initials and acronyms to facilitate my delivery. I will begin with the first legislative exercise, which is the two pieces of subsidiary legislation made under the SNSO in May 2025. On 13 May, the OSNS regulation was made under Section 110 of the SNSO. At the same time, the Prohibited Places Order was also made under Section 42 of the SNSO. They were made for the better carrying into effect of the provisions of the Hong Kong NSL on the mandate of the OSNS for safeguarding national security in Hong Kong. The OSNS regulation covers three major areas. First, the Hong Kong SAR is subject to OSNS oversight and guidance under Article 49 of the Hong Kong NSL. The OSNS regulation outlines that the Committee for Safeguarding National Security of Hong Kong shall make overall plan for and coordinate the implementation of OSNS opinions. Second, the regulation provides for the implementation details to facilitate OSNS to implement their duties under Article 55 of the Hong Kong NSL, which provides that the OSNS shall appoint approval of the Central People's Government, exercise jurisdiction over a case concerning 4 types of offences endangering national security under the NSL, only when any of the 3 rare special circumstances specified in Article 55 occurs. Third, the regulation provides for specific details regarding protection for OSNS and its staff in the performance of its mandate, as stipulated in the Hong Kong NSL. This includes the requirements of the SAR government and public servants to provide, in accordance with the law, all necessary and reasonable assistance, facilitation and support to OSNS. On the other hand, the Prohibited Places Order declares the premises where OSNS performs its mandate as prohibited places, and the relevant prohibited places are all premises solely occupied by OSNS to perform its mandate. The 2 pieces of legislation I just mentioned reflect consistently on the responsibilities mentioned in the white paper. Namely, the central government bears the fundamental responsibility for affairs concerning the national security in the Hong Kong SAR, while the SAR shoulders constitutional responsibility for safeguarding national security. Now, let me move on to the second legislative exercise, the amendments to the prison rules made on 15 July 2025. The prison amendment rules were made to strengthen the capabilities of the correctional officers in maintaining security, good order, discipline of prisons, and essentially echoing my topic, to further improve the legal system and enforcement mechanisms for safeguarding national security. The prison amendment rules have introduced amendments in relation to prison visits. The key here is to clearly define the statutory purposes of visits, such as facilitating rehabilitation of the persons or preparing them for reintegration into the society. Any visits which are not for such purposes will be refused. And the reason for the amendments is fundamentally straightforward. This enhances prison security and management, which protecting lawful rights and interests of prisoners. And in fact, such rules are not uncommon. The amendments were introduced with reference to relevant laws and practices in other jurisdictions. As we can see from the slides, the UK, the US, Canada, Australia, and New Zealand all have put in place statutory provisions empowering prohibition and imposition of restrictions and conditions on visits, having regard to factors such as national security and prison security. Further, the rules introduce a new regime to restrict individual legal practitioner to visit or have connection with a particular prisoner. It's important to be aware that while the vast majority of legal visits are bona fide, according to our past experience, a mechanism to safeguard against abuse is necessary. The new regime is to empower a magistrate to issue a warrant authorizing Correctional Services Department to impose restrictions. But let's also keep in mind the magistrate may only issue the warrant if he has reasonable grounds to do so, and the prisoner may also make an application to a magistrate to revoke or vary any warrant issued. In regard to prisoners' legal consultation, under the new mechanism, the prisoner is only restricted to consult a specified legal representative. He is still allowed to consult another legal representative of his choice, and hence his right to confidential legal advice is not affected. Besides, the court would act as a gatekeeper to ensure the restrictions are imposed necessarily and reasonably. In contrast, in other jurisdictions such as the US, New Zealand, New South Wales of Australia, the correctional authorities may restrict prisoners' access without judicial authorization. Getting back to the white paper, Hong Kong SAR is committed to providing a secure, humane, appropriate, and healthy custodian environment for all prisoners, guaranteeing their access to essential medical services, mental health counseling, and religious services. The prison amendment rules have demonstrated that the rights of prisoners would be adequately protected and the rule of law would be adhered to while we strive to safeguard national security. And I refer to the white paper, which states that Hong Kong's endeavors in safeguarding national security are not, as mentioned by the Secretary for Justice, not to pursue absolute security. Respecting and protecting human rights, underpinned by the basic law and international covenants applicable to Hong Kong, is a salient feature, an important experience of Hong Kong SAR's efforts to safeguard national security and must be adhered to. The last legislative exercise I'd like to mention is the NSL Implementation Rules Amendments, gazetted just last month, 23rd March, which happens to be the second anniversary of the implementation of the SNSO. The amendments are within the scope of enabling power granted by the Standing Committee of the National People's Congress of the PRC to the CE in the committee under Article 43 of the NSL itself. In order to investigate offences endangering national security in a lawful and effective manner, the IR Amendment Rules enhance procedures and mechanisms for law enforcement agents to exercise the duties and powers under Hong Kong NSL and set out stringent requirements for them to exercise the powers. And I'll come on to those requirements. The lawful rights and interests of individuals and organizations are adequately protected in accordance with Article 4 and 5 of the Hong Kong NSL. As you can see, the judiciary plays a gatekeeping role to ensure such powers are subject to checks and balances. And recently, there were a lot of discussions and misunderstandings about the power to require password under the amendment rules. At the outset, it must be emphasized that this power is not arbitrary, as it is only for obtaining evidence from persons being reasonably suspected of having committed offenses endangering national security. And the prerequisite is that a warrant has been obtained from the court to search the contents of the digital device. And only in exceptional circumstances where it would not be reasonably practicable to obtain a warrant that the police can execute a warrantless search. Section 3 of Schedule 1 clearly specifies that only where there is reasonable ground for believing that the digital device contains evidence necessary for investigation of an offense endangering national security, or procurement or preservation of evidence, or the protection of any person's safety, and when it would not be reasonably practicable to obtain a warrant, a police officer not below the rank of an assistant commissioner of police may authorize the search of the digital device without a warrant. Such warrantless search power of the police reflects the principles held by the Court of Appeal in the case of Shem Wing Ken in 2020. This is consistent with the protection of freedom and privacy of communication under Article 30 of the Basic Law, as well as the protection of privacy and correspondence under Article 14 of the Bill of Rights. And just as the White Paper has mentioned, Hong Kong's judiciary and legal community stand resolutely as guardians of the rule of law, and Hong Kong's original legal system, including the common law, has been maintained and developed. Some may query whether similar mechanisms exist in other common law jurisdictions. And in fact, many do have some legislation in place which authorize law enforcement agents to require provision of decryption methods of electronic equipment during investigations and evidence gathering. For instance, the Regulation of Investigatory Powers Act 2000 of the UK imposes a disclosure requirement in respect of any protected information if it's necessary in the interest of national security. And there are also similar provisions in Australia, New Zealand, Ireland, and Singapore. I could go on and on. In the US, warrantless searches of people's cell phones are expressly allowed at ports of entry, including airports. A recent example is put up on the slide for your easy reference. Again, I must stress that one of the significant features of the amendment rules is the independent judicial power, which continues to play the gatekeeping role. The law enforcement authorities are required to apply to the court for permission to exercise its powers, such as to require a suspect to surrender travel documents, to confiscate proceeds of crime, or to forfeit offense-related property. Another gatekeeping mechanism under the amendment rules is the relevant review mechanism for a affected person to apply to a court for review of the authority's decision. I will give you some examples. Specifically under Schedule 2, a suspect can apply to the court of first instance for review of a magistrate's refusal to return travel documents or granting him permission to leave Hong Kong. And under Schedule 5, the party receiving a notice to provide information may make an application to the court of first instance for revocation or variation of the notice. Now, having gone through these three legislative exercises, all can see that in safeguarding national security, the Hong Kong SAR strictly abides by the Constitution, the Basic Law, the Hong Kong SAR, NSL, and local laws. Hong Kong has been resolutely fulfilling its constitutional responsibility to safeguard national security by continuously forming a comprehensive legal framework in which Hong Kong NSL and local legislation are closely aligned and function as an integrated whole. Looking ahead, the Legislative Council will work closely with the Hong Kong SAR government to fully leverage on the strengths of one country, two systems by ensuring a high level of national security, thereby making Hong Kong a safe and happy home for Hong Kong people and one of the best places for business in the world. Thank you very much.
Thank you, Ms. Gan. Our next speaker is Mr. Anthony Chow. Mr. Chow is the Deputy Director of Public Prosecutions in the Department of Justice. He currently heads the Commercial Crime Subdivision of the Prosecutions Division. He has prosecuted many cases involving offenses endangering national security, and you would actually see his footprints in all the landmark national security law cases across all levels of our courts. Mr. Chow will review two recent judgments of major national security cases to illustrate how our courts discharge its duties of preventing, suppressing, and imposing punishment for offenses endangering national security, and in the process continue to adopt the common law approach in construing the national security law and relevant local legislation in the adjudication of cases. Mr. Chow.
And thank you, Jonathan, for the generous remarks. Distinguished guests, ladies and gentlemen, it's my great honor to speak to you today at the National Securities Legal Forum on the topic Clearing Up Confusion and Misunderstandings, Hong Kong's Endeavors in Safeguarding National Security. Building on Ms. Ken's insightful discussion from the legislative perspective, I would like to approach this topic from a case law perspective, drawing on two recent and highly significant judgments on offenses endangering national security. First, it is the HKSAR versus Lai Chi-ying, the first trial on charges of conspiracy to collude with external elements, and the second one is HKSAR versus Yang Shuying, Clarice, and others, the so-called primary election case on conspiracy to commit subversion. As the appeals of those cases remain on foot, I will not speak about the merits of the outcome. Instead, I want to highlight some of the key legal principles made by the court and what these cases demonstrate about the court's approach to NSL. Much has been written and said in Hong Kong and overseas about the implications of the NSL for judicial independence, human rights, and rule of law. My proposition today is this. When we read these judgments carefully, what we see is the common law at work. We see courts using the familiar tools, text, context, purpose, and constitutional background to construe NSL provisions in a principled way. We also see a consistent effort to safeguard rights and freedoms guaranteed by the Basic Law while protecting national security. Now, let me turn first to the case of Lai Chi-ying. Mr. Lai was convicted after trial and of 3 charges, one relating to conspiracy to publish seditious publications, and 2 concerning conspiracies to collude with external elements to endanger national security under Article 29 of the NSL. He was sentenced to 20 years imprisonment, reflecting the grave nature of the offences found by the court. The trial lasted 156 days. The court considered the evidence of 14 prosecution witnesses, examined more than 2,200 exhibits, over 80,000 pages of trial bundles, and heard Mr. Lai's own testimony over 52 days. Throughout, he was represented by a team of experienced counsel. Taken together, these features underline both the complexity and scale of the case and the court's close attention to detail, as well as its careful observance of fair trial guarantees and its commitment to protecting rights under the Basic Law. In its detailed 855-page of reasons for verdict, the court found that, first, Mr. Lai was the mastermind of the collusive conspiracies. Second, he was consciously using Apple Daily and his personal influence to carry out a consistent campaign with a view to undermining the legitimacy or authority of the CPG or the HKSAR government. And third, after the NSL came into operation, he continued to express an anti-China stance and carry out campaign for requesting sanction and other hostile activities against the PRC and the HKSAR. As the court finds, Mr. Lai's intent to solicit intervention and the imposition of sanctions was demonstrated through his long-term connections with his extensive foreign network, including senior US officials or former officials as detailed in Annex 1 attached to the reasons for verdict. This is the Annex 1 which attached to the reason for verdict now shown on the screen. The court found that Mr. Lai's sole intent was to bring about the downfall of the Communist Party of China, even if that required the sacrifice of the interests of the people of the PRC and the HKSAR. So what did the court have to decide as a matter of law? Article 29 of the NSL criminalizes those who request a foreign country or external elements to impose sanctions or blockade or engage in other hostile activities against the HKSAR or the PRC. Against the factual background, one of the key issues was how to construe the word request and the phrase sanctions, blockade, or other hostile activities, which are used in the short form SBHA, in the context of Article 29, and how far do those concepts reach? In answering those questions, the Court anchored itself in the authoritative guidance of the Court of Final Appeal in HKSAR versus Lai Chi-ying. That's another case regarding Article 42 sub 2 of the NSL bill. And another case, HKSAR versus Lui Sai-yu, and applied the established common law principles of statutory construction. The NSL, the Court stressed, must be construed in light of its ordinary meaning, purpose, and context. The NSL functioned coherently with the HKSAR's legal system and sought convergence, compatibility, and complementarity with local laws unless they were expressly or impliedly displaced in the event of inconsistency pursuant to Article 62 of the NSL. Applying those principles, the Court held that request bears its plain and ordinary meaning. It simply means to ask and to appeal for something to be done. It includes direct or indirect appeals for action. The focus of the offence is the act of making the request, coupled with the intent that sanctions be imposed by a foreign country or external element. The offence does not require the request in question result in sanctions being imposed. On the scope of SPHA, the Court again adopted a purposive and contextual reading. It held that SPHA should be given their plain and ordinary meaning. It extends to measures like technology embargoes. It is not confined to any measures targeting the PRC or HKSAR itself, but also covers any those targeting officials of the PRC or the HKSAR acting in their official capacity. Now, if I may turn to the Court of Appeal judgment of Yang Shuying, Clarice, and others concerning the so-called primary election. In that case, 47 defendants were charged with conspiracy to commit subversion, contrary to Article 22, subparagraph 3 of the NSL. 31 pleaded guilty, 14 were convicted after trial, 2 were acquitted. Those convicted received terms of imprisonment ranging from around 4 to 10 years. Earlier this year, the Court of Appeal dismissed the defendant's application for leave to appeal against conviction and sentence, and also the prosecution's case-stated appeal in relation to one acquittal. The case concerned a scheme described as a constitutional mass destruction weapon, designed to create a constitutional crisis in Hong Kong. The terms of the scheme involved abusing the LegCo members' powers under the Basic Law with the specified purpose of, first, obtaining a controlling majority in the LegCo to indiscriminately veto any budget. Second, compelling the chief executive to dissolve the LegCo so as to paralyze the operation of the government. And third, ultimately causing the chief executive to resign. Article 22 of the NSL criminalizes those who commit the prohibited acts by force or threat of force or other unlawful means. One of the key legal controversies at trial and on appeal centered on the meaning of other unlawful means. When approaching this issue, the Court reiterated that the contextual and purposive approach established in common law should be adopted when considering the provisions of the NSL. It held that the term other unlawful means, it is not restricted to those involving force or the threat of force. It is not confined to acts constituting criminal offences, and it may include an act committed in breach of an article of the Basic Law. Having regard to the NSL's legislative purpose and the constitutional order in the HKSAR, the Court held that the scheme clearly amounted to other unlawful means within Article 22 of the NSL. And taken as a whole, The scheme plainly constitutes an abuse of the powers conferred by Article 73, subparagraph 2 of the Basic Law, which empowers the LegCo to examine and approve budgets introduced by the government. That provision does not, however, entitle LegCo members to exercise such power in a manner that undermines the very foundation of the Basic Law. Now, let me draw these threads together. What those judgments reveal is that the courts of Hong Kong have approached NSL offences in precisely the same principled manner they bring to any question of statutory construction, in accordance with the established common law approach. The courts have scrutinized each element of the offence with care, acquitted where the evidence fell short, and explicitly balanced the protection of national security against the fundamental rights and freedoms guaranteed by the Basic Law, upholding the rule of law as an integral pillar of Hong Kong's legal system. As emphasized in the White Paper, respecting and protecting human rights is a salient feature and important experience of the HKSAR's efforts to safeguard national security and must be adhered to over the long term. At the same time, safeguarding national security is not and cannot be the responsibility of the courts alone. Article 6.1 of the NSL states that it is the common responsibility of all the people of China, including the people of Hong Kong, to safeguard the sovereignty, unification, and territorial integrity of the People's Republic of China. In this spirit, echoing the opening remarks made by our Secretary for Justice, I would like to conclude with one line from the White Paper which expresses this in vivid terms. Like air and sunshine, national security is often taken for granted, yet cannot be lived without. Safeguarding national security is a responsibility shared by all members of society. Everyone is a stakeholder and beneficiary, and no one can be a mere spectator. Thank you very much.
Thank you, Mr. Chow. Now, our last speaker is Professor Granville Cross, SC. He was called to the Bar of England and Wales in 1974 and to the Hong Kong Bar in 1981. He was appointed Queen's Counsel in 1990. He served as the Deputy Crown Prosecutor of Hong Kong from 1990 to 1997 and as the Director of Public Prosecutions from 1997 to 2009. Professor Cross will take us through how human rights are fully respected and protected under national security law through a comparative study of national security laws and cases in overseas jurisdictions. Professor Cross, please.
Secretary for Justice, distinguished guests, ladies and gentlemen. I'm most grateful to the Secretary for inviting me to participate in today's forum, which provides everybody with an opportunity to focus upon national security developments. The way in which the Hong Kong National Security Law and the Safeguarding National Security Ordinance have been integrated into our legal system deserves to be better understood, and this forum is furthering that objective. As the White Paper makes clear, security is the foundation of social stability and the safeguard of people's well-being. However, persistent efforts to ensure national security are required, and comparative analyses can help to identify the direction of travel. After all, some of Hong Kong's national security laws bear a striking resemblance to those of other jurisdictions, including those on extraterritoriality, sabotage and technology crime. And this should surprise nobody, as the laws of, for example, Australia, Canada, and the United Kingdom were closely studied when Hong Kong enacted its own national security laws in 2024, Article 23. However, there is one stark difference, and it concerns human rights. As the White Paper acknowledged, Hong Kong has in place, quote, sound provisions on the protection of human rights and freedoms enjoyed by all Hong Kong's residents in accordance with the Basic Law and the relevant provisions of the international covenants applicable to Hong Kong, close quote. In contrast to other places, it is no exaggeration to say that Hong Kong's two national security laws are human rights heavy. In both the NSL Article 4 and the SNSO Article 2, the need for human rights to be respected is highlighted. The importance of protecting the fair trial guarantees embodied in the ICCPR is also emphasised. Both laws indicate that human rights must be respected and protected, which is reassuring for everybody involved in criminal justice. However, anybody searching the parallel laws of other jurisdictions for similar provisions, including the United Kingdom's National Security Act of 2023, will be wasting their time. They are silent on human rights protections in national security prosecutions. And the impact of Hong Kong's human rights protections was evident at the recently concluded security trial of the Apple Daily founder, Jimmy Lai Chi-ying, a trial which I may say was skillfully prosecuted by Mr. Anthony Chow. Mr. Lai enjoyed the presumption of innocence, was defended by a top-class legal team of 6 barristers, and was able to challenge the prosecution's evidence and to give evidence in his own defence. He was only convicted after the Court of First Instance fully evaluated the evidence and concluded he was guilty beyond reasonable doubt. Now, although Lai chose not to challenge his national security convictions, he did appeal against his 2 fraud convictions dating from 2022. And on February the 26th this year, the Court of Appeal quashed his convictions and set aside his sentence of 5 years and 9 months imprisonment, which was a vivid demonstration of independent judicial power. Earlier, in 2024, the Court of Appeal had also quashed his conviction for organising an unauthorised assembly, citing evidential deficiencies. Therefore, let nobody ever underestimate the judiciary's unswerving pursuit of just outcomes. Now, although these similarities between some of Hong Kong's national security laws and those elsewhere are obvious, others are less apparent. However, whatever the labels actually attached to particular laws, the underlying objectives of the various laws in different places are invariably the same. And this could be demonstrated by examining 3 offence provisions. Now, the first situation involves dealing in a national security absconders funds, etc., contrary to Section 90 of the SNSO. And this was illustrated in February by the conviction of Kwok Yin Sang for attempting to deal with, directly or indirectly, any funds or other financial assets or economic resources belonging to a national security absconder, namely his daughter, Anna Kwok. As Kwok himself knew, his daughter is accused of colluding with foreign forces to endanger national security, and she is actively engaged in seeking to harm Hong Kong's interests in the United States, where she works for the China-hostile Hong Kong Democracy Council. And perhaps inevitably, Kwok's conviction attracted or triggered ill-informed foreign criticisms. Whereas, for example, United States Senator Jeff Merkley from the Senate Foreign Relations Committee claimed it was intended to silence dissent. Elaine Pearson, the Human Rights Watch's Asia director, said it showed the Hong Kong authorities were determined to silence peaceful activism abroad. As for the hyperbolic Benedict Rogers from the United Kingdom-based Hong Kong Watch, he described Kwok's conviction as, quote, an appalling, outrageous miscarriage of justice. And so it was, ladies and gentlemen, that global attempts were made to mislead public opinion into believing that Hong Kong was somehow unique in having a law in place to deter people from assisting criminal fugitives, which could not be further from the truth. Throughout the common law world, countries have enacted laws to discourage people from harbouring, financing or otherwise assisting criminal suspects. This is as true of the United Kingdom as it is, for example, of Australia, Canada, and the United States. In all of those places, anybody who provides sustenance of whatever sort to wanted persons will face the consequences. And it matters not whether they are family, friends, or associates, as the British model illustrates. Whereas it is a specific offence under the United Kingdom's Criminal Law Act of 1967 to assist an offender, any dealing with the offender's money is criminalised under the Proceeds of Crime Act of 2002. Assisting an offender encompasses providing material support, washing clothes to remove evidence, or providing a hiding place. Even actions by parents to help their errant progeny are prosecutable and punishable upon conviction with a maximum sentence of 14 years imprisonment. Moreover, ladies and gentlemen, under the United Kingdom's Terrorism Act of 2000, it is an offence for somebody to use or possess any property or enter into a funding arrangement if the person knows or has reasonable cause to suspect that it may be used for the purposes of terrorism. It is also an offence for a person to facilitate the control of terrorist property, unless the person can prove he did not know and had no reasonable cause to suspect that the arrangement related to terrorist property. Now, this is as tough as it gets, and one tragic case recently demonstrated that a familial relationship between the parties does not begin to qualify as a defence under British law. On June the 21st, 2019, a married couple from Oxford were found guilty at the Old Bailey, no less, of sending £233, which is about $298, to their Islamic State-supporting son in Syria, and sentenced to 15 months imprisonment, suspended for 12 months. John Letts and his wife, Sally Lane, were convicted of entering into a funding arrangement for the purposes of terrorism. Their son, Jack Letts, was a convert to the Islamic State who travelled to the Middle East in 2014, making his way eventually to the Islamic State-controlled areas in Syria. Now, although the parents explained that they trusted their son when he told them he was a translator and a civil administrator for the Islamic State, and that he wanted to leave Syria, it was of no avail. Despite not supporting Islamic State, its aims or methods, they were hit with the full force of the law. After the convictions, the Crown Prosecution Service's Jenny Hopkins said the case showed that even parents who cared for a child were, quote, breaking the law if they give money that could be used for terrorist purposes, even if they don't sympathise with terrorism. And in response, Letts and Lane declared, "We have been convicted for doing what any parent would do if they thought their child's life was in danger. We believe we've been badly let down by the police and the authorities. We tried to do the right thing." However, this cut no ice with the prosecuting authorities. Now, although it is natural for people to want to help relatives in trouble, there must be limits. If red lines are crossed, there will never be consequences, as is globally acknowledged. Kwok now knows this, and so do Letts and Lane, and people in similar circumstances everywhere can now see how things stand. Now, although both cases involved family tragedies, Merkley, Pearson and Rogers only waxed lyrical over Kwok's predicament. They had no words of sympathy whatsoever for Letts and Lane, and their double standards are exposed for all to see. I turn now to the second and related issue of how the Hong Kong authorities act against specified absconders accused of endangering national security. Such people are existential threats, and every effort is necessary to neutralise them and to procure their return to Hong Kong to face justice. This is why, for example, the SNSO enables the Security Bureau to cancel the Hong Kong SAR passports of specified absconders, to prohibit any dealings in the funds or assets of an absconder, to criminalise the leasing of immovable property to or from an absconder, and to prohibit joint ventures, partnerships, or any like relationships with an absconder. Now, although, for example, Hong Kong Watch criticised the consequential measures that were taken by the authorities against specified absconders, claiming they showed that Hong Kong's authoritarian status was becoming a reality, it has intriguingly never once complained about the equivalent US laws which provided Hong Kong with a model. By virtue of the US Code of Federal Regulations, Title 22, Section 51, a law enforcement agency can ask the Department of State to revoke a passport if an individual is wanted on a criminal charge and an arrest warrant has been issued, or else if a court order has been issued prohibiting an individual from leaving the country. Thus, for example, Edward Snowden, the former United States National Security Agency intelligence contractor and whistleblower, who exposed malfeasance at the heart of Western intelligence in 2013, had his passport revoked, his US passport revoked, while he was in Hong Kong, leaving him in limbo. Now, ladies and gentlemen, when the SNSO was enacted, it criminalised external interference endangering national security, which is the third offence I will now examine. Its ingredients are closely defined, and they involve an intent to bring about an interference effect by collaboration with an external force to do a particular act, but provided only that improper means are used when doing that act. The offence must be aimed at endangering national security, meaning that normal international exchanges in areas like academia, commerce and culture are not affected. Although nobody has ever been convicted of this offence in Hong Kong, the same cannot be said of other jurisdictions, which have parallel laws, and I'm thinking here of places like Australia, Canada, the United Kingdom and the US. For example, both Australia's National Security Amendment Espionage and Foreign Interference Act of 2018 and the UK's National Security Act of 2023 introduced offences that criminalise collaboration with a foreign power to interfere with their internal affairs through various types of improper conduct. Both laws were influential in the drafting of Hong Kong's own external interference law. Thus, whereas Hong Kong's external interference law criminalising acts which have, quote, an interference effect, the UK's foreign interference law criminalises acts of, quote, prohibited conduct. And while the Hong Kong offence explains the improper means of doing an act, the wording largely mirrors that used to define prohibited conduct in the UK offence. However, the laws are not identical, and both the British and the Australian laws are designed to make it easier to prosecute national security suspects. Although Hong Kong's external interference law requires intent, the UK law introduced a lower test, making it possible to prosecute somebody who is only reckless. Australia has also adopted a lower test, with reckless foreign interference being criminalised under the Criminal Code Act of 1995. So what this means, therefore, ladies and gentlemen, is that whereas a specific intent is required in Hong Kong before a suspect can be convicted, a suspect elsewhere can be convicted without having sought a specific outcome. And with the lower recklessness test, it suffices for the suspect to have behaved in a way that created a high risk of interference. Nobody should be surprised, therefore, that the foreign interference laws in other jurisdictions have been more liberally deployed without the restraint which is apparent in Hong Kong. In 2024, for example, Di San Duong, a Vietnam-born businessman and a prominent figure in Australia's Chinese community, became the first person in Australia to be convicted of planning to commit an act of foreign interference. He had close ties with the governing Liberal Party and was accused of ingratiating himself with a government minister, Alan Tudge, by means of a hospital donation, hoping to influence Australian government policy in a manner favourable to the Communist Party of China. Now, although Duong insisted he was generally concerned about rising anti-Chinese sentiment in Australia during the COVID-19 pandemic and wanted to promote the goodwill of the Chinese-Australian community by donating to pandemic relief, he was imprisoned for 2 years and 9 months. In other words, Duong was being prosecuted for activities that in many places would be viewed as either public-spiritedness or political lobbying. Now, buoyed by its success, the Australian authorities then targeted a businessman called Alexander Sergo. Once again, there was a China angle, and he was convicted just last month in a Sydney court of reckless foreign interference for having compiled reports for 2 individuals suspected of being Chinese spies. Although Sergo, who ran a business in Shanghai, provided information which he said was already in the domain and objectively was worthless, prosecutors argued that he believed the individuals were working for China's Ministry of State Security and was reckless as to whether it could support Chinese intelligence activities. While there was no evidence that Sergo, who admitted to misleading the two individuals, revealed any national security secrets, he now faces up to 15 years imprisonment. And it is fortunate, I suggest, for Hong Kong residents that their prosecutors do not also target people with evidence which can only be described as flimsy. Now, although the US does not have a specific interference law mirroring Hong Kong's, it has alternatives of its own. For example, the offence of acting as a foreign agent without notifying the Attorney General was invoked in 2023 against an American citizen of Chinese descent called Li Tangliang, a hotel worker. Without notifying the Attorney General, he allegedly acted as an agent of the PRC, collecting information about Chinese residents in the Boston area and passing it on to the Chinese government. Whereas the authorities portrayed Liang's acts as efforts by the Chinese government to silence critics abroad, his lawyer, a lady called Derege Demisi, contended he was simply an organizer in Boston's Chinese-American community and that the charges he faced were, quote, scare tactics. Demisi told Voice of America the case would have meant nothing if it did not involve China. She added that its aim was scaring people and it achieved that purpose. Now, although Liang was acquitted, his prosecution demonstrated the dangers faced by Chinese people living abroad and the ease with which a foreign agency-type law can be used in the West to intimidate anybody who does not embrace a particular worldview. Now, in conclusion, ladies and gentlemen, the three laws I've examined all have their counterparts elsewhere and are being applied with a restraint which is often lacking in other places. They are no more draconian than laws elsewhere, and they are sometimes milder. However, national security is a work in progress, which is why the White Paper notes that states which practice the common law continuously refine their legal systems in response to evolving national security landscapes. Although, therefore, the national security laws have been successful in restoring stability and prosperity in Hong Kong, they must be kept under constructive review in the best interests of the one country, two systems policy. Thank you very much.
Thank you, Professor. To conclude this panel session, I can do no better than reminding ourselves what the White Paper set out as concluding remarks. Hong Kong's endeavors to safeguard national security under the one country, two systems policy have been extraordinary, with achievements that are widely recognized. Its stability and prosperity today have not come easily, and hard-won progress must be cherished. A safe Hong Kong that is free, developed, open and vibrant, aligns fully with the one country, two system policy, serves China's fundamental interests, benefits the residents of Hong Kong, and meets the interests of external investors. These endeavors are, at their core, efforts to uphold and advance the one country, two system policy, protect the fundamental human rights, dignity and well-being of Hong Kong's 7.5 million residents, and promote world peace and development. Looking ahead, Hong Kong will fully leverage the strengths of one country, two systems, and better integrate into and contribute to China's overall development. That concludes today's panel discussion. Thank you very much.
Thank you. Thank you very much for the insightful discussion. And well, may I invite moderator and also our distinguished guests to please join in a group photo to commemorate such a fruitful session. Thank you very much. Thank you. Ladies and gentlemen, please give them a warm round of applause. Thank you.再次感谢我们台上所有的主礼嘉宾，我们的演讲者，谢谢你们的分享，谢谢。Thank you very much, and please have a seat off the stage. Thank you. We will now move on to our second panel discussion on building consensus, experience, and insights of Hong Kong in safeguarding national security. Our distinguished speakers in panel session 2 will share with us their insights regarding how the national security legislation in Hong Kong, which emphasize that rights and freedoms are respected and protected, have created a more secured environment, thereby fostering a more stable and predictable business and development environment in Hong Kong. The panel will also talk about Hong Kong's recent efforts in raising the awareness of safeguarding national security among our youth. Ladies and gentlemen, please give a warm welcome to the moderator of this session, Ms. Melissa Pan, BBS MHJP. Thank you. And Ms. Pan will be joined by 3 distinguished speakers for this session. And they are Dr. William Wong, SC, BBSJP, member of the Basic Law Committee of the Standing Committee of the National People's Congress. Mr. Yu Pen Chang, GBS SBS JP, Vice Chairman, the Hong Kong General Chamber of Commerce. Ms. Joyce Chan, Rule of Law Education Ambassador. Thank you. Thank you once again for our distinguished guests, and please have a seat. May I now pass the time to Ms. Pan. Thank you very much.
Good afternoon, Secretary for Justice, distinguished guests, ladies and gentlemen. Welcome to the panel 2 of our National Security Legal Forum. I'm Melissa Pang, moderator of this session. Today we gather to explore how the national security law anchors our shared duty, how the newly released white paper clarifies our path, and how we align this with the full implementation of the 15th five-year plan, where high-level security safeguards high-quality development. Now in panel 2, our theme is building consensus, experiences and insights brought by safeguarding national security in Hong Kong, with a focus on a crucial idea: safeguarding security with greater openness. The white paper before us makes a powerful statement that safeguarding national security is not a job of a select few. It is, and I quote, a responsibility shared by all members of society. Everyone is a stakeholder and beneficiary, and no one can be a mere spectator. This is not just a legal principle, it is a living reality that plays across our courtrooms, our boardrooms, and our classroom. To explore this reality, I have the privilege of introducing 3 distinguished leaders, each operating on a different front line of national security. First, from the legal front line, a practicing barrister. He's a senior counsel, a member of the National People's Congress Standing Committee's Basic Law Committee. Please welcome Dr. William Wong, Senior Counsel, BBSJP.
Distinguished guests, ladies and gentlemen, I'm indeed honored to share with you my views on this very important occasion. There's a saying that a good lawyer lives with the law and perhaps also sleeps with the law. Now, in my view, the same goes to a good citizen. As our moderator rightly points out, every citizen is a stakeholder in upholding our core values, including the value of rule of law, and that by definition
includes our national securities law. If there's one message that I'd like to pass on to all today, is that the only way we can safeguard our national security law is by fully appreciating its value and upholding to it. In this city, we walk our talks. We practice our values, sometimes without even noticing it. Now, with what is happening in the international geopolitical environment in the last year, including in the past few months, and in fact is still continuing developing at present, I think people are starting to appreciate national security and basic law and order are of paramount importance to one's daily life and a society's economic development. I was in the beautiful and spectacular city of Dubai in this January with a delegation from our airport authority. Standing now is set to witness the city's present predicament, whilst the present regional war conflicts prevails. It's lucky that I did not implement my plan to buy a piece of property in Dubai after my return. Now, honestly, every time when I return to Hong Kong, when my footsteps on the soil of Hong Kong, I feel a great sense of security and peace of mind. And the reason is simply because we here in Hong Kong have a very strong tradition of rule of law. We have no fear that we will be arrested arbitrarily. Our properties are sacredly protected under the basic law by our courts, exercising independent judicial powers without fear or favor. Nowadays, we see that an impartial judiciary appears to be an endangered species. But here in Hong Kong, we still have a fiercely independent judiciary. I'd like to share with you my 3 observations since the enactment of the National Securities Law. Just now, Mr. Chow for the public prosecution outlined some figures for your consumption. A key feature of our national security law is that our national security law is fully transparent. What do I mean? Since the enactment of our national security law, every single trial, and I emphasize every single trial, took place in open court, including the recent trial of Mr. Jimmy Lai. We have no secret trial. The judgment and the reasoning therein are open to all. Reasonable people may legitimately differ in their views on certain parts of the judicial reasoning. However, the fairness of our system is guaranteed by our appellate system. We here in Hong Kong respect judicial reasoning, but not partisan political narrative. And this is a continuous feature of the practice of our national security law. Now, secondly, perhaps it's counterintuitive, but our national security law is in fact a fundamental guarantee of our citizens' fundamental rights and freedom. Why do I say that? Some may even suggest that our national security law limits our freedom, and somehow we have to strike a balance. Is it so? Now imagine a city without traffic rules. Do you think that you would have more freedom or less freedom without traffic rules? The reason why we can enjoy the freedom to have a game of chess is precisely because people voluntarily observe the rules of the game. We have freedom of speech. There's no doubt about it. But we also want to be free from, say, internet or online bullying. We want to be free from defamation and internet fraud. Hence, as the white paper quite rightly points out, security provides the foundation for development. National security law makes sure that we have a level playing field to develop our own economic interests and pursue our aspirations. In this jurisdiction, we cannot make money by simply posting a tweet on a Friday. That is illegal under our Hong Kong law. Now, thirdly and finally, the fundamental motivation for us to value and uphold our laws, including our national security law, in my view, must be solidly founded with our profound love of this very city and our own country. We collectively want our city and our country to thrive and our citizens to lead a fulfilling and prosperous life here in Hong Kong. Hong Kong is our home, and we want our home to be safe. And therefore, we like to breathe our law, live with our law, as if national security law and other bodies of law in Hong Kong is part of daily living. It's air, it's oxygen, it's sunshine, as Mr. Chow just quoted from the white paper. And I sincerely believe that it's only with a full appreciation of the value of our law, including national security law, that we will wholeheartedly support the law and uphold it. And that is the solid foundation of the development of our national security law. Thank you very much.
Mr. Wong, thanks for your comments and your perspective on the rule of law, national security, and the love for Hong Kong and our motherland is deeply meaningful and truly inspiring. Let me introduce the second speaker. We have Mr. P.C. Yu. Mr. P.C. Yu is the Vice Chair of the General Chamber of Commerce. Mr. Yu, the floor is yours.
Secretary of Justice, distinguished guests, ladies and gentlemen, good afternoon. Thanks, Melissa, for the introduction, first of all. Secondly, I'm very honored to be here to speak to this distinguished forum, and I will present the views from the business community. In today's global business environment, certainty has become one of the rarest and most valuable assets. We operate in a world marked by rapid technological change, evolving supply chains, and geopolitical uncertainty. Investors, businesses, and institutions increasingly seek predictability, rule clarity, and stable operating environments. Jurisdictions that can offer these qualities gain a decisive competitive advantage. This is the context in which Hong Kong's value to the business community must be understood. Despite the turbulent times, Premier Li Qiang at the March 2026 China Development Forum stressed China's commitment to be a cornerstone of certainty and a harbor of stability by offering a predictable, high-level and open business environment with reliability and steady governance. As mentioned by Secretary of Justice and previous speakers, Hong Kong is geared to be not just an international financial hub, shipping and trading hub,
but also as a core in safeguarding China national security under the framework of one country, two systems. In recent years, Hong Kong has seen the completion and clarification of its legal framework following the promulgation of the National Security Law, the local enactment of Article 23, and most recently, the publication of the White Paper. The boundaries, principles, and safeguards are more clearly defined. From a business perspective, this is an important development. What investors value is not ambiguity, but clarity. These measures have helped draw a clearer line between what is prohibited and what is clearly legitimate. Business, professionals, academic, and commercial activities. As a result, compliance uncertainty has been reduced and operational predictability has improved. Independent assessment continued to reflect this improvement. Last year, Hong Kong General Chamber of Commerce commissioned an independent professional agency to conduct an evaluation, the Asian Cities Internationality Index, which is in short ACII, which focused on 11 key cities in Asia across 7 areas. And these are 1, business and economy, 2, quality of life, 3, infrastructure and connectivity, 4, innovation and ideas, 5, human capital diversity, 6, cultural interaction, and finally, government and legal system for businesses. The index evaluates the global connectivity, economic openness, and cultural diversity of major Asian cities, providing valuable insights for businesses, policymakers, and investors. Hong Kong ranked first with 73.7 points. As the most international city in Asia, followed closely by Singapore with 73.5 points and Tokyo 70 points. Leading in the business economy area and is well-rounded in others. Being second in the area of quality of life, infrastructure and connectivity, and human capital diversity. Third in the dimension of government and legal system for business, and fourth in both the dimensions of innovation and ideas and cultural interaction. The results reaffirm Hong Kong's role as a global financial hub, a center for international events, and an international hub for world-class education, as well as its free, safe, and stable living environment, supported by strong infrastructure, connectivity, diverse quality of life, and a home for world-class academics. The ACII findings are reinforced by Hong Kong's wider economic performance, including its stock market, residential market, new family offices, and IPOs, details of which are readily available and which I will not repeat here. I'm sure the audience are as convinced as I am of how safe and thriving Hong Kong is today, with the city's booming events and art scenes attracting not only local tourists but also expats from all over the world choosing to settle here. I would also like to take this opportunity to share the personal viewpoint from a member of one of the foreign chambers that I received this morning. He shared that it has been interesting to observe the evolution of Hong Kong's business landscape over the past few years. From his own perspective, the implementation of the National Security Law has played a significant role in restoring the stability and is essential for any thriving commercial hub. In the business world, predictability and order are paramount. The period of uncertainty that preceded the law created a challenging climate for operations and long-term planning. Since the implementation of NSL, he has perceived a gradual but noticeable return to the stability that Hong Kong was and is known for. The sense of security has allowed the Hong Kong business community to refocus on growth, investment, and the day-to-day operation that drives its economy. Rather than hindering commerce, the stability has, in his views, reinforced Hong Kong's position as resilient, reliable, and prosperous gateway for international trade. It is encouraging to see the city not only maintain but also reinforcing its status as a key financial center. And he remains optimistic about the continued economic opportunities that this stable environment fosters. In closing, Hong Kong's strength lies not in rhetoric, but in delivery, in its ability to combine openness with order, global standards and clarity, and commercial flexibility with predictable rules. With a more complete legal framework, strong institutions, and a level playing field for businesses, Hong Kong today is safer, more stable, and more investable. For businesses and investors seeking certainty in an uncertain world, Hong Kong remains a compelling place to deploy capital, build partnership, and plan for the future. Thank you.
Thank you, Mr. Yu, for your insights on certainty, rule of law, and Hong Kong competitive edge as a top global hub. Those are very and highly compelling. And I certainly agree that a stable and clear framework makes Hong Kong a prime choice for global investors. Now we come to our third speaker. She is from the front line of hearts and minds, an educator who is building the future, one student at a time. Let's welcome Ms. Joyce Chan. She's the head of Integrated Humanities and National Education Team Convener at a secondary school. Thank you, Joyce.
Thank you, Melissa. Secretary for Justice, distinguished guests, ladies and gentlemen, good afternoon. I'm honored to represent the Royal Ambassador to introduce how national security education is implemented in Hong Kong schools, with particular reference to the sharing content from my serving school, St. Paul's College. Through a balanced approach that involves campus culture, classroom learning, experiential activities beyond the classroom, and professional sharing within the learning community, we strive to cultivate students a sincere understanding of national security and a sense of responsibility to safeguard national interests. To begin with, national security education in our school is first strengthened through regular ceremonies and students' training, so that the message is not confined to textbooks, but becomes a meaningful daily practice. For instance, we conduct weekly flag raising and speech under the national flag. These routines help students internalize respect for the nation in an authentic and consistent manner, while also creating an atmosphere in which values are learned through repetition, participation, and reflection. In addition, students are trained as members of the flag-raising team. At the same time, we also nurture the Constitution and Basic Law student ambassadors, through which students learn how national security is closely connected to the rule of law, constitutional order, and the civic responsibility expected in society. To establish a positive learning atmosphere of national security education, our school also has a range of board displays that showcase the core messages from time to time. To strengthen students' understanding of national security education in a more interactive and peer-led manner, the ambassadors' learning is reinforced through diversified learning experiences that connect national security education to broad and concrete themes. For example, the Space Exploration Workshop showcased different models of rockets so that students can appreciate China's achievements in space exploration and connect it to the importance of safeguarding outer space security. The Ocean Park Workshop helps students connect learning with the safeguarding of ecological security by enjoying their moments with our lovely pandas. We also provide opportunities for students to explore deep-sea security concepts through visits to defense-related or strategic facilities, such as visiting the amphibious assault ship Hainan Hu 31 and the guided missile destroyer Changsha Hu 173. We further broaden students' horizons through other student activities. For instance, the Road Ambassador program allowed me to experience the fun mock trial experience. I then brought my ambassadors to this interactive activity. Through mock trial activity, students learn how legal reasoning and the spirit of the Constitution and basic law can be applied in scenarios that demand fairness, responsibility, and respect for the rule of law, thereby deepening their comprehension of political security and legal culture. Moreover, participation in platforms such as the China National Youth Model, CPPCC, strengthens students' understanding of governance and civic participation. When students take part in these activities, they experience national security education not merely as abstract knowledge, but as values and competences demonstrated through dialogue, decision-making, and responsible expression. Alongside these school-based routines, national security education is further embedded into learning within classrooms. For example, in junior history, students learn China's reforming opening up as part of economic security and discuss the return of Hong Kong to the motherland in the context of political security and homeland security. National security education is also woven into junior geography through topics such as food problems and farmlands in China. Students explore food security and resource security. The integration continues in citizenship, economics, and society, where students learn about media and information literacy by building awareness of data security and responsible information use. They also learn about public finance of Hong Kong, connecting their understanding of financial arrangements with economic security. Through subject planning, students develop a structured and comprehensive understanding of national security, guided by academic concepts and the learning logic appropriate for different levels. However, classroom learning alone cannot fully achieve the purpose of national security education. Therefore, our school also places strong emphasis on learning beyond the classroom. In senior forms, mainland study tours are conducted to provide structured exposure and learning opportunities that broaden students' perspectives. Other subjects like integrated humanities, Chinese history, and history will organize exhibitions, museum, and site visits to consolidate their national security knowledge. In junior forms, we focus on school-based project learning and experiential learning, namely Project ACE. Project ACE refers to a project that serves as a call to action for the community and environment. Let's not implement it in isolation. It encourages organic integration between subjects such as history, geography, and citizenship, economics, and society. This integration helps students connect facts and concepts across disciplines, and it supports deeper learning by allowing students to interpret real-world issues using multiple subject lenses. It is designed so that students transform what they learn from subject knowledge into real actions, experiences, and reflection that connect directly to national security awareness and sustainable development. For Form 1, the focus is action for the community, linked to cultural security, with an emphasis on the preservation of tangible cultural heritage in Hong Kong. For example, students visited the Green Hub, which is the former Tai Po police station, to learn how to appreciate the value of tangible cultural heritage, explore how community participation helps protect cultural identity. Moreover, the Green Hub is also revitalized into a learning center related to sustainable development, so that students also learn about resource security through the organic garden inside the Green Hub. For Form 2, the focus is action for the environment with multiple dimensions. Students explore intangible cultural heritage in the context of cultural security. For instance, they learned about Teochew culture through Kung Fu tea making and Teochew mooncake making, showing that culture is not only about remembrance, but also about continuity and community responsibility. They also study local farming in Hong Kong. Through plowing, irrigating, and weeding, they understand the importance of safeguarding food security and resource security. After all these experiential learnings, students will film videos to raise awareness of the related national security themes. In addition, we recognize that national security education should be strengthened through a learning community rather than efforts made by individual schools alone. Therefore, our school also conducts professional sharing within the learning community. Invited by the EDB Moral Survey and National Education Division 2, or MCNE2, we organize an open class and 2 sharing sessions. These professional exchanges help teachers learn from one another, refine practices, and adopt improvement strategies that can strengthen students' learning outcomes across schools. In summary, national security education in Hong Kong schools is implemented through a coherent and multi-layered approach. Therefore, as role ambassador, I would like to conclude with a sincere message. National security education is most meaningful when students can feel its relevance in everyday life, experience its value through participation, and internalize it through reflection and action. Lastly, allow me to quote a line from the speech under the national flag written by one of my student ambassadors. National security is about our environment and social harmony. A safe country is a place where schools can open every morning without fear, where families can travel during holidays, and where students like us can dream about the future. Thank you.
Thank you, Joyce, for sharing with us such an inspiring program that nurture the responsibility and pride in our future generation. Now is the Q&A session. Let me turn to Mr. Wong first. Okay, Dr. Wong, I think there's a question we want to ask. As an ordinary citizen, what do you think we can do to uphold our national security law?
Well, I actually reflect upon this question, and if I may be allowed to digress a little bit. I remember that when I was a pupil, my mentor, who is John Griffiths, a former Attorney General in Hong Kong, he told me that, William, we are in a very blessed profession. We earn decent living by writing little essays, by turning up in court to do little arguments. So, as and when we can, we should repay our debt to our profession. I remember that until this day. And therefore, I think drawing an analogy, we should cherish what we have in Hong Kong, an appreciation that what we have in Hong Kong, we should not take it for granted. And I think the appreciation that we all collectively owe a duty to make Hong Kong a better place is a starting point for us to start to, from our own inner self, start to say to ourselves that we have a duty to protect our city, to uphold our law, including the NSL. I don't believe, and I have many pupils in my life, I don't believe you can teach your son or your daughter to study hard. Right? I don't think it works by just asking them, you better study hard. It doesn't work. The way it works is for them to truly appreciate, like Ms. Chen has done, by letting our citizens know the value of national security law and knows why we need to uphold it. And it's from that point that it will become something comes naturally and something we don't need to mention it year after year. It comes naturally as light follows day. So I think it is through the good work of Ms. Chen and many Ms. Chens, if I may say so, that we can implant or spread a sense of gratitude and a sense of responsibility and a sense of the obligation to repay the debt which brings us where we are today. I think it's with those appreciation that we can, as a society, collectively, make Hong Kong a better place. Thank you.
Thank you. I think one has to be grateful to what we have, and I think it's great that we have this education in the school, primary, secondary. That's very important to instill the right core value. I mean, we always say we have to know our responsibility, but some stress too much about our rights. We have to understand rights and duty are two sides of the same coin. It's very important to know that. Okay, the next question I'll ask Mr. Yu. I think you make a very powerful reminder to us that certainty is a scarce resource. And this is a very important element that investor will consider whether to invest or not. And it's very great that we learn of the good news that Hong Kong ranks first in the Asia Cities Internationality Index, ACII, which indicates Hong Kong's endeavors in safeguarding national security have contributed to stability and certainty in the market. Can you share some stories or from your personal experience?
Thank you, Melissa. Certainly. You know, I've been traveling quite a lot for the last few years, and quite often I've been asked, how is Hong Kong nowadays? Are you still have the freedom that you used to have? Can you travel? Can you talk freely? I said, come on, Hong Kong is great nowadays, especially with the implementation of the NSL, now with Article 23. We have very peace and stable environment. Business is carry on as usual, not like the last decade, especially in the final year of the last decade. I'm an operator in a retail store. You know, for the second half year of 2019, I have to look at the streets every day. If the violence or the protesters are getting too close, I have to close my shop until I don't know when. And that's really affecting my business and affecting the perception overseas of how Hong Kong is. And I tell them, nowadays I'm operating as usual. I can plan my business. I can look forward to more investment coming in. In fact, as I mentioned earlier, there are more investment, more family offices coming into Hong Kong, and I'm sure the economy will pick up eventually and will be great. Second story I'd like to share is I was meeting a banker in my office a couple of weeks ago, And it's her first time to be in this part of the world. And when she learned that she was appointed to be head of the Hong Kong branch of this bank, she was very adamant. She was really worried, she told me. She said, will I be able to walk around freely? Will I get my phone checked by authorities and what have you? And then after 6 months, she said, wow, Hong Kong is a real fantastic city. It's a great place to live. It's freedom. Now she can travel everywhere freely. Her money can be moved freely. You know, this is what business wants. She has to go back and tell her colleagues, her clients in Europe, you know, Hong Kong is still booming. Is a great place to invest, and it's very stable. And then another thing that I was surprised, because she's from one of the city deemed to be one of the safer one in Europe, she said, you know, she has 2 teenage daughters, and she said, you know, usually when at home, back home, she said she wouldn't dare to have her daughter out in the street after 8 p.m. at night. But in Hong Kong, you know, they can go out until 11, 12. I'm not worried, because Hong Kong is a safe city. So, tell you, seeing is believing. I said, encourage your friends, your families, and your clients, come to Hong Kong, have a look for themselves. Don't read the things in the media. It's not really true. It's not true at all. Come, visit. It's a great place.
Thank you, PC. I really agree with you that seeing is believing. And actually, being here is really believing. I think every one of us can be the ambassador. Tell our friends around the world, ask them to come to Hong Kong and be here. And talking about ambassador, I would like to talk to Joyce. She has a very special post, I would say. She is the representative of the Rule of Law Education Role Ambassadors under the Role Stars Train the Leaders program. This program is organized by the DOJ. So you are an ambassador. Why don't you tell us more about this program? And also, I'm interested in the program about the ACE program.
Thank you, Melissa. Yes, first of all, I'm one of the role ambassadors, and I actually gained a lot of experience and knowledge after attending the courses and programs organized by the Department of Justice. For example, I myself experienced a mock trial and pretending to be one of the only lawyer of the group that I am competing with. And I am lucky enough to be the best lawyer that day, and I find it so fun, having a mock trial. Of course, fun means that I really enjoy the experience, but at the same time, I believe my students can also learn to respect rule of law, to uphold rule of law, and also be a responsible citizen. So that's why I invited my ambassadors to also join the program, and that's why it is shown in the photo that I showed just now, and they enjoyed it. And I think as a role ambassador, it is my duty to show students the importance of safeguarding national security. And of course, today's program is national security law as well. So I have to instill the mindset that, besides learning what national security education, we also need to know the importance of understanding national security law, and they could learn about it through textbooks and also through programs. So this is my role. And for my ambassadors, just now I've introduced the Project ACE about filming videos, right? So it is actually about the lesson time constraints, because all my Form 1 and Form 2 students, they go to different experiential learning experience, yet they cannot go to every single program. So how can we maximize the learning outcome? So I asked them to film promotional videos, and in July, we have a Project ACE celebration, and of course, we select the best ones. We collect around 80 videos from Forms 1 and 2, and then we teachers select the best 6 of them. Why 6 of them? Because there are 6 themes. And then we select the 6 videos, and then we showcase them in front of Forms 1 and 2. And this is a peer learning journey. So they appreciate others' video and learn about the different national security themes. And this is how I maximize the learning outcome. So this is my sharing. Thank you, Melissa.
Thank you so much. Ladies and gentlemen, the white paper says that everyone is a stakeholder and beneficiary, and no one can be a mere spectator. Today, we heard from a lawyer, a barrister, a businessman, and a teacher. 3 very different roles. But they share one conviction, that safeguarding national security under one country, 2 system is not a burden, it's their duty. It is the foundation upon which Hong Kong's rule of law, our economic vitality, and our children's future are built. Security enables openness. Openness drives prosperity. And prosperity, shared by all, is the strongest consensus of all. Please join me in thanking the 3 panelists.
Thank you. Thank you very much for another enlightening discussion. And may I invite all of you to please have a group photo. Thank you. So please join me in giving them a big round of applause. Thank you, our moderator, and also our distinguished speakers, for such an engaging and also stimulating exchanges. 再一次感谢我们所有的讲者，谢谢你们宝贵的分享，谢谢。Okay, thank you very much. Thank you, and please have a seat off the stage. Thank you very much. 请就坐。So as we approach the end of today's forum, we are honored to invite Dr. Zheng Guoquan, SBS JP, the Deputy Secretary for Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, to the stage to deliver the closing remarks. DSJ, please.
Professor Wan, distinguished guests, ladies and gentlemen, good afternoon. Having heard our eminent speakers share views on the practice of Hong Kong's national security laws and on how Hong Kong continues to thrive in an orderly and stable environment, today's legal forum has successfully come to an end. And I would like to take this opportunity to summarize and share with you the key takeaways of this forum. First, this year is the inaugural year of the 15th Five-Year Plan, a pivotal year that Hong Kong is poised for leapfrog development in both its economy and society. At this juncture, the white paper released in February this year has significant guiding value as an authoritative pronouncement to Hong Kong. It stated outright in its preface the highest principle of fully, faithfully, and resolutely implementing the policy of one country, 2 systems is to safeguard national sovereignty, security, and development interests. It also comprehensively outlined 5 important areas, including the unrelenting fight for safeguarding national security in Hong Kong, the central government's fundamental responsibility for national security matters concerning Hong Kong, Hong Kong's achievement in fulfilling its constitutional responsibility for safeguarding national security, Hong Kong's transformation from disorder to stability and prosperity, and creating high-standard security for the high-quality development of the one country, two systems policy. Last but not least, the White Paper reminds us once again that Hong Kong has the constitutional responsibility of effectively safeguarding national security, and that we, including the HKSAR government and all sectors of the community, should proactively implement the requirement. In this regard, we are honored to have had Professor Wang deliver a keynote speech earlier this afternoon, which reaffirmed our delegation and solidified our commitment to the essence and principles set out in the White Paper. Second, the Hong Kong National Security Law was enacted to address prominent issues related to national security in the implementation of one country, two systems, and to prevent national security risk. Its ultimate purpose is to uphold the one country, two systems principle, maintain prosperity and stability in Hong Kong, and serve the best interests of the Hong Kong and its residents. Together, the Hong Kong National Security Law and the Basic Law constitute a legal foundation for Hong Kong to safeguard national security. In panel session 1, we were most delighted to have in our company Mr. Jonathan Cheung, SC, Honorable Calvin Chan, Professor Cross, SC, and our Anthony Chow to review the developments of Hong Kong's national security laws, including how Hong Kong continues to improve the legal system and enforcement mechanism for safeguarding national security. Most importantly, without compromise to the practical need to address security risk, they highlight the significant features of the improvement exercise that we have been undergoing while strictly adhering to the rule of law principle with reference to the recent major national security cases and comparable overseas legislation. I'm sure we all find their sharing to be insightful, informative, and leave us on a high note. Third, in every community, security is a prerequisite for development, and development provides a guarantee for security. Without national security, we cannot offer better development and a better life for residents, and we cannot provide better protection for the legitimate rights and interests of investors. We know from experience that the Hong Kong National Security Law and the Safeguarding National Security Ordinance have been jointly serving as a shield for safeguarding national security in Hong Kong, and the society continues to remain stable and prosperous. Last year, Hong Kong was the world's fierce economy. We were also number 1 in global IPO market rankings, and number 1 as Asia's largest hedge fund hub and cross-border wealth management center. Having said that, we must not overlook the importance of national security education as an essential tool for encouraging a proactive and continuing commitment from the community at large in safeguarding national security. On this front, I'm indebted to our panel session 2 guest speakers, Ms. Melissa Pan, Dr. William Wong SC, Mr. P.C. Yu, and Ms. Joyce Chen for their sharing from the holistic perspective and from the standpoints of the courtroom, boardroom, and classroom. Their contributions sparked our exploration of how Hong Kong could achieve a dynamic balance between development and safeguarding national security. Safeguarding national security is a responsibility shared by all members of society. Everyone is a stakeholder and beneficiary, and no one can be a mere spectator. The fruitful discussion by our distinguished guests this afternoon provides an excellent starting point for us to understand the essential requirements of the white paper. It's my hope that the insight shared by our guests this afternoon could further enhance public awareness on safeguarding national security and enrich our understanding of the importance of the white paper. As the white paper affirms, we should all share a common aspiration: stability and peace, not riot and turbulence, vitality and prosperity, not decline and decay, unity and solidarity, not opposition and division, civility and rule of law, not lawlessness and disorder. We must bear that in mind and cherish the safe and stable environment today. Thank you very much.
Thank you very much, ESJ, and please have a seat. Ladies and gentlemen, the National Security Legal Forum 2026 has successfully concluded. We would like to extend our warmest appreciation to the moderators, speakers, distinguished guests, and each of you for joining us tonight. And we wish you all a pleasant and enjoyable evening. 我们今天的论坛已经圆满成功，再次感谢各位的莅临，谢谢。A kind reminder, please leave the simultaneous interpretation device on the chair before you leave the venue. 溫馨提示，請各位將我哋嘅即時傳譯機放返喺我哋嘅凳上面，多謝合作。溫馨提示，請大家在離開之前，把即時傳譯機放在椅子上，謝謝你。